That's what I got first.
Okay, thank you.
But it's big, so.
Call this meeting to order, and Brother Garvin, would you do the invocation for us, please?
Would you join me in prayer? Our Father in heaven, we thank you for this beautiful day. We thank you for your love and your much care and your grace. We just ask now that you'd bless each of us, bless our families and our loved ones, be especially with all the citizens of Cherokee Nation. Forgive us for our sin. In Jesus' name I pray. Amen.
Amen. Thank you. Roll call.
Meredith Rayleigh.
Here.
Bill England.
Here.
Bill John Baker.
Here.
Jack Baker.
Here.
Harley Buzzer.
Here.
Juliet Coates.
Here.
Bradley Cobb.
Honey.
Joe Crittenden. Jody Fishingham. Here. Janelle Fulbright. Here. Dawn Garvin. Chuck Hopkins.
Here.
Tina Glory Jordan.
Present.
Curtis Snell.
Here.
Chris Suck.
Here.
David Thornton. Kara Callan Watts.
Bonnie.
We have a quorum.
We have a quorum. Next order of business is approval of the February 28th regular session minutes.
I move that they be approved.
Second.
Moved and seconded. Any discussion on the February 28th regular session minutes? Any discussion? All in favor signify by saying aye.
Aye.
All opposed, same sign. The minutes stand as written. The March 10th subcommittee meeting minutes.
I move to be approved.
Second.
Second, moved and second. Any discussion on the subcommittee minutes? Any discussion? All in favor signify by saying aye.
Aye.
All opposed, same sign. Next item are reports, and the first report is Ms. Wright, Marshal Service. I think she has provided us a written report. Is she here? She's right here. Up.
Good afternoon.
Good afternoon.
A little couple pulled me over and the restaurant was closed and they were trying to find some place to eat. It was an emergency.
That when you said you were pulled over, the police pulled you over.
I don't know if you had time to look at the report. I got it in late today.
Are there any questions or comments? Yes, Mr. Hoskins?
Thank you, Madam Speaker. With respect to the subject of inspecting, I guess for lack of better words, the problem dogs, the vicious dogs, we've had some discussion of that in past meetings. And what I'm curious about is, do we have the resources with our existing staff to do that? Is it an additional burden on our officers to be essentially going out and doing animal control, which I think is important, but do we have the resources right now to do it?
We do not. And part of that is even if we have the manpower to go in and what we've done is go door to door and say, is this your dog or whatever, we don't have the facility for the animals. We don't have the equipment to transport or to catch, all of those things. And I've talked with the Councilwoman Jordan here at one point about some of that, and then we've had some community meetings on housing issues, and some of the talks concerning animal control was if there was a way to maybe get some contracts with local pounds or local animal control people. You would still have to find the resources for that, though, you know, to pay them to go out to those county areas. And also currently, even if we were to confine a dog, they will not accept one that's not within their area.
Could you, not on the spot, but could the Marshal Service estimate the cost of doing what we'd like to do, which is to take care of the vicious dogs within your jurisdiction, without taking a position on whether you want to do it or not, but just tell us what resources would need if we want to meet that objective?
I haven't looked at the cost. I can look at the cost and get back to you because you would have to purchase the equipment for and house the animals, and then also have a regulation or law on whether you put the dogs down or not, and then so you have the cost of feeding them or the cost of a vet to take care of them, all of those things, and I have not looked at the cost. I'd have to.
Between now and the next Rules Committee meeting, do you think it's reasonable that you could come up with the various options you discussed and the cost
I can.
attendant to those? Thank you, Minister.
Yes. Dr. Cobb?
Did we ever hear anything, did that go anywhere with Ramona?
As far as I know, they have signed the document, and they have asked that we do some publicity thing so they get into a newspaper. And that date hasn't come from them on when they may want to do that.
Okay,
And we will notify you on that so that you can be a part of that.
appreciate it.
This question, Dr. Cobb, we couldn't hear up here.
There was some interest in the city of Ramona in the Keeler district of cross-deputization, and I was just asking where we stood on that.
All right.
And the other one was another council person had inquired about Muldrow, and they also were signing, and I think they are just going to sign it and we're going to issue cards, but they actually wanted something publicity-wise on Ramona.
Mr. Buzzard?
Yes, Sharon, on your last bullet, begin process to move into 3 general policing stations to better serve areas and become more cost efficient. What are you doing? What are we doing here?
A year or so ago, we presented a 5-year plan. We were hoping that we would be able to grow into that plan, and we sort of just stagnated. So I've decided that whether or not we gain momentum or not, we're going to go ahead and start moving toward doing that. And we had described 5 areas of police stations, substations, and trying to get manpower into those. What we've done is generalize 3 bigger areas, and then we're going to put if you want to call them a commander in each area, give them a set of guys, and they will work that area. So you'll have a set of people who are going to work like south of Stillwell down. You'll have a central area, and then that piece probably we're looking at right now, we haven't defined those lines, but above Locust Grove and up would be the 3rd district, and those people would then be able, we hope, to be better at policing because they're going to work only that area. They'll know the people better. They'll know what events are going on, and that's where we're trying to get to.
Now I know that probably maybe don't have any places picked out before, but 4 or 5 years ago, we had made some office space available down at Bull Hall office, and that's right into our trust lands in there. So I wanted to throw that in to make sure that, it's still there. I think it's still there anyway. So
We'll look into it. I know that one of the things with the 3 general areas, of course, we have the office here, but in the southern area, both the casino and Muskogee Clinic has offered up office space for that group of people down there. And then in that area up there, the casino, and we didn't know if JPD or somebody, even Oaks, had offered some space. So I'll tell them that Bull Hollow may be the other
yeah, I think there's still some space there.
area they may have a space to set things up in.
Okay. Thank you, Mr.
Mr. Snell?
Yes, I would like to request that some marshal service be provided at the gigging contest at Badenall this year. There was a young Indian lady died there last year from alcohol poisoning, I think. And they said that the public was just kind of having a big party and no law enforcement whatsoever there. Not to mention that also the Delaware County.
We've been up there the last 2 years, so there was some law enforcement because we worked with Delaware County and we sent 2 or 3 officers with 4-wheelers. But I'll make sure they get up there again this year and work through Delaware County on that again.
All right, thank you.
Any other questions or comments for Ms. Wright? Do you have anything further, Sharon?
I just wanted to, and I don't know if the council people that were concerned before are still here, but, this got to you so late, I just did want to point out that Poe pled, and that was that big C&E case that they were concerned about, that started in the last term, and he finally pled on money laundering, and also we haven't got the public documents, but apparently made a statement about the kickbacks that he took while he was an employee. So that actually has finally got a pleading on that.
Ms. Jordan?
Which casino and how much money was it?
It was Catoosa, and the case was where he had contracted a IS type person to do some work for the casino, and then there was some issue of whether or not there had been some kickback between the two parties, and it's been in the system for 3 years maybe or so, quite a while. And it was, for a while there we were doing a lot of updating, but it had stayed in the federal system, and of course they wouldn't let you give out too much information until they had something. But we finally got yesterday he pled on money laundering.
How much?
$25,000.
And that goes back to us?
Well, they haven't had the sentencing, and I haven't had the public documents sent to me yet on what was in those statements. So when I get that, I'll send them on forward to you.
Anything else, Sharon? Thank you. Next report is Ms. Hammond's in Justice Department.
Thank you. Good afternoon.
Good afternoon.
I apologize for not getting a report in. I was out of town during the due date and we didn't get one in. Let me hit the highlights of what's happened in the last month. We continue to be very busy with all 3 ICI lawsuits in Oklahoma County, Cleveland County, and in our tribal court. We have a jury term that's going on right now. I have one of my assistants conducting a jury trial on a juvenile case, even in Tennessee, down at our tribal courthouse. We have also, in the last week, been very busy with the news of the tobacco arbitration panel's decision. That was released out from under the confidentiality order this morning. I emailed a copy to your office. Your counsel had previously received one. I brought some hard copies with me for anyone who doesn't have electronic access, for members of the public or the council. I guess the good news, if there is any good news in this, is that we have our questions answered. The bad news is the answer is no. It is worse than what we had anticipated. Succinctly, the panel held that the state did not breach the compact by repealing their sales tax, that the nation, not the nation's retailers, but the nation, in coordination with the retailers, did breach the compact by allowing retail-to-retail sales to take place. The arbitration panel thirdly held that Oklahoma Tax Commission Rule 12 was valid and was not in violation of the compact, but that Oklahoma Tax Commission Rule 13 was violative of the compact, and the panel enjoined the state of Oklahoma from ever trying to enforce Rule 13. Let me briefly tell you what that means. That means that retail-to-retail sales are violative of the compact. The compact is in effect right now and will remain in effect until either its expiration or the parties mutually agree to rescind or enter into a new compact. We are bound by the terms of the compact to enforce it. So the Tax Commission will be sending notification to all of our retail licensees about the order and what the effect of it. some of the questions, trying to anticipate the questions you might have. Do we have a right of appeal? We didn't provide one in the compact. When you agree to arbitration, you can kind of design your own world in arbitration, and we didn't design ours very specifically. So we didn't mention appeal at all. If we were going strictly under the federal rules of arbitration, there is a right of appeal to a district court. It is extremely, extremely limited, and the arbitrator's decision is granted high deference, even higher deference than normal administrative bodies. So, I'm not telling you that there is no right of appeal, I'm telling you what the limitations might be. Renegotiation with the state of Oklahoma. That, of course, is an option, and I'm sure that we will be speaking to the state of Oklahoma about it. Enforcement. We have a duty under the compact. We agreed to enforce its terms. I've talked to you a little bit about that. What will the state do to enforce? I don't know. When will they do it? I don't know. What can they do? They can impose sanctions, restrictions, whatever, on wholesalers. Their ability to do anything on Indian country is limited, but it's the wholesalers that they can have the most impact on. I think one thing that we had planned initially on talking about today before the order came out was the Favored Nations Clause. That was also one of the final things addressed in the order. And again, you know, that I guess if there is a good side, it's that we got our question answered. But the arbitrators made very clear that Favored Nations Clauses only apply to compacts entered into after the time that we entered into ours. They said the Favored Nations Clause is only triggered by compacts entered into after February 9th, 2004. So just very, very briefly, ladies and gentlemen, that's the order. I will try to answer any questions that you may have.
Dr. Cobb, and then Mr. Hoskin.
Diane, can you clarify the ability to do anything on any Indian trust land? That was your statement.
So it's very limited. I mean, we have always tried to zealously protect our sovereignty against any regulation or enforcement by the state or any other jurisdiction on Indian country. I'll be honest with you, cases in the last few years have not gone the way that tribes would like them to. So that's, I wish I had a more definite answer for you. Certainly, if I were the state's counsel, I would advise the state to regulate those entities off of Indian country, the wholesalers, the supply. And we know that under the Citizen Ban case, which led to all of this, that was one of the things the Supreme Court of the United States suggested. While you're limited in what you can do on Indian country, you can regulate wholesaling coming into Indian country.
Okay. That answers. Thank you.
Mr. Hoskin.
Thank you, Madam Speaker. I have a couple of questions. The first one is that the gag order was imposed by the arbitral panel, is that correct? I was curious about the timing. That they lifted the gag order effective this morning. What triggered that specific time frame?
That was my request.
That it be this morning that it was lifted?
That it be today.
Okay.
Because I couldn't, it was my request, it was agreed to by the state, and I just logistically could not think of a way both to inform this body, for the tax commission to inform the retailers, to fully discuss it with that confidentiality order still being in place. So we agreed, the parties agreed, we agreed to a prospective date when it was going to be lifted.
And I appreciate that you had to get multiple parties involved. I personally, if I had my preference, would have, I think the gag order could have been lifted sooner, is my sense. I mean, the arbitrary award issued on the 19th, and maybe giving us a little more time to digest it. I know there's other considerations involved, but I just want to say, I guess for the record, I appreciated more time, but I understand you've got other considerations that are into play, but personally I would have appreciated more than just the few hours that I got to digest it. I think I've got this section 2, Part B, paragraphs 4 through 7 are dealing with the retail-to-retail sales. And I realize, the game is over, so to speak, because I understand it's difficult to get a federal court to vacate this arbitral ruling, but doesn't it seem, they talk about the exception swallowing the rule. In other words, if the parties would have contemplated that there could have been these retail-to-retail sales, well, that would have been the exception to the 86 cents pack, would have swallowed the rule. But, aren't they really reading things into that compact that aren't there? They're reading something about that exception that simply isn't on the face of the compact. So to me, they went outside of the face of the compact to say, well, the parties really meant the exception was not there, was different than it was.
I disagree with a number of things that the arbitrators did. I disagree with their characterization of what we pay as an excise tax instead of as a payment in lieu of tax. We were very careful in our briefings, and that's also, of course, something that we can provide anyone now is all of our briefs and the arguments that we made. We didn't agree to pay a tax because, as you know, we don't have to pay any tax at all on sales to our own tribal members. No sales, no state tax. What we agreed to was a payment in lieu of tax, a PILT or PELT, depending on how you want to use the acronym. So I disagreed with that. I disagree with some of their other characterizations. Another thing that they didn't do, other than Mr. Raley sort of in his special concurrence, they refused to look at anything that happened outside the four corners of the document. And we argued that they should. That they should consider parole evidence, they should consider the statements of state officials, because there was obviously ambiguity in the compact itself. We asked them to consider all that, and they refused to.
Then with respect to, let me back up. I guess there's further hearing on damages, so there'll be another arbitral ruling concerning the damages, for example, for the retail-to-retail sales. Will that be something that...
For the arbitrators specifically said that there would be a hearing later on as to damages. That has not been set yet. We don't know if or when that will happen. Obviously, we could reach some sort of agreement with the state that would preclude that from happening. But as of right now, the language is, I think it's in the final paragraph, that they would have that in the future. That's not been said.
Did the compact itself, on its face, contemplate that the nation would be liable for actions of retailers that might be inconsistent or in violation of the compact? Because they're saying the nation's responsible. So I'm just curious, I've read the compact, it's been a while, but does it expressly state that the nation would be liable, or do they say, well, that's implied?
Well, it doesn't. What it says is that the nation agrees to require as a condition, I've highlighted this, so I'm reading verbatim part of it to you, that all nations' retail licensees will comply with the provisions of the compact. So we agreed that we would enforce the provisions. Does that say we're liable for damages? No, it doesn't say that explicitly. I think the arbitrators also found that not only did we allow it to happen, but that we somehow were complicit in the retail-to-retail sales scheme.
And then finally, if I could, the idea of asking a federal district court to vacate all or part of this arbitral ruling, that action itself would be of some controversy. In other words, it's unclear that we actually have that avenue.
It is.
And if we do go down that path, what's our time frame? Does the clock start to run because the arbitral ruling is issued?
You know, once again, we didn't say anything at all about it in the compact. Mr. Huskins, I looked it up yesterday under the federal arbitration rules, and now I've forgotten what it is. It is longer than the usual, appeal time frame. It's not 20 days. It's something greater than that. I'm sorry. I can get you that specific answer.
That's fine. Thank you. Thank you, Ms.
Mr. Soap?
Yes, I've got just a quick question. As far as now that you have a basic ruling and you've said enforcement, what are the things that you will be enforcing as far as the consequences to the people that may choose not to obey the ruling or adhere to the ruling?
Of course, we have the tax commission. That's their job, is to regulate. It's my understanding they're going to be sending notice out as soon as possible, today, I believe, to all of the licensees, directing that retail-to-retail sales cease. Then they will be responsible for enforcement. If, because we now know any dispute has been clarified, that having the lower the 6-cent stamp for sale in stores outside that zone, those are improperly stamped cigarettes. Improperly stamped cigarettes are contraband. Those could be seized. They could be seized by the commission. It's also, I believe, a crime under our law. So there are
Right,
ramifications.
that's kind of what I was, what's the charges or the extent of?
There's both civil, the commission enforcement actions, and they could answer that, I'm sure, much better than me, but they can do seizure, they can impose fines, they can suspend licenses, they can revoke licenses. If someone's found in possession of contraband on the criminal side, that can be seized and they can be charged.
Thank you.
Ms. Fishing Hawk?
We've got in front of us a copy of the most favored nation clause that was invoked. Can you explain to me why that wasn't made part of the contract or the compact?
It was. May I see what you're referring to? I'm not sure. Thank you. This is the letter that Mr. Fike sent. I believe that it was, Counselor, the folks from the commission can more specifically answer that. I think that it was.
It was invoked?
I think so.
You finished, Jody?
Yeah.
Hopkins?
Yeah, with respect to the most favored nation clause, I think Councilor Fishing Hawk wanted to know if there was a most favored nation clause in the compact, and there was. That's
There
correct.
was.
And then the question was it invoked? And General Counsel's fight letter was an invocation of that provision. The arbitrators ultimately ruled that under the circumstances, because the other compact predated or existed at the time of the compact, that you couldn't invoke the most favored nation clause in those circumstances. Is that accurate?
You can only invoke favored nation clause for those after February 9th, 2004.
Are there any, do we know of any compacts that have, in terms of, is it prospective, do we know of any compacts out there that we couldn't invoke it on now? Because we certainly aren't foreclosed from invoking the clause, we
No, we're
just
not.
couldn't at that time.
Once again, the tax commission can probably answer this more specifically than me. I believe that the only ones that have been entered into during that period, well, entered into is not exactly the right word, but the only ones that have had more favorable terms during that period were, now the word escapes me, were continuations of previous contracts, and some of those are in litigation. There have been no new ones. There have been extensions, that was the word I was looking for, of previous ones.
So do you read the arbitral ruling as even an extension is not a new compact? That's what the arbitrators...
I don't know. I mean, they didn't specifically address that.
Because it seems to me, I think there's a compact out there that, for reasons that escape me, actually doesn't have an expiration date on it.
There is.
And if that's the case, then it seems to me you can make the argument, well, it has to have some sort of term, and it has to have some sort of renewal, even if it's automatic. But it seems to me that every time a compact is renewed,
That it's a new compact.
that it's a new compact. And so I think we ought to explore that and not not give up the fight. And I know you're not, but my point is, let's explore that. Thank you, Madam Speaker.
That's a very good point, and I do encourage you, I'm relating to you what I remember from what the tax commission's told me. They have more specific information on those things.
Ms. Jordan?
Well, he caught it on the end of his communication. I want her to explore why an
Absolutely.
extension is not considered a new contract.
And I don't know that it's not, Counselor. I mean, that's an argument that could be made, that extensions are new compacts, or that we ought to be entitled to the terms for an extension. Some of those are involved in litigation as to that very point of Were they extended? Were they extended in time? Did the state let them go on?
Well, that brings the pre-04 contracts past the date that the arbitrator has in his, or their decision, and those clauses, there are some clauses in those agreements, if they're considered new contracts, that are more favorable to us.
I agree. I agree.
So
And it's certainly something that we will consider.
And it didn't appear to be addressed here.
In the decision, it's
No.
not. Doesn't say anything at all about the extensions, renewals, any of that.
Anything else? Mr. Thornton?
Are they, does there happen to be any nations that actually do not have a compact at this date
I think so.
that have refused?
I think so.
Could you find out, please?
Ms. Swepson would be able to tell you. I'm sorry. I think so.
Okay, who? Who can tell us?
Ms. Swepson, Sharon Swepson, the Tax Commission Administrator. Yes, I think she's behind me somewhere. I can feel her looking.
What's the question?
Pay for that.
Sharon, are you back there somewhere?
What is the question?
Point of order, Madam Speaker, I don't think that the other councilors heard Councilor Ford's question.
Okay. Councilor Martin, would you repeat your question?
Are there any other nations or tribes that have refused and have not entered into a compact with the state?
Yes, there are. I don't have a complete list. I can get you that.
I appreciate it.
I believe one of them, if I'm not mistaken, hang on just a second, is the Creeks. And then, yes, the Creeks, that's what I just emailed him going when you asked the question. The Creek Nation does not have a compact, but there may be others, but I know that one for sure.
Thank you.
On the most favored nations clause that you were asking about, there are the ones that are out there that we've looked at. They're not newly entered into compacts. They are either being renewed or they are in litigation right now and they're just being held at that rate, but they have not. It's not a new compact. So, and there's 4, and I have a list of those.
Mr. Hoskin?
You're saying it's not a new compact, but you're not closing the door on the idea that a
No.
renewal is a new contract as
Exactly.
contemplated by the most favored
Right.
nation clause.
Right.
Okay.
Sharon, don't leave yet.
I gotta make sure.
Ms. Fitchinghott?
Anywhere in our tax code, does it address store-to-store sales?
Not in the actual rules and regs. There is a legislative act 0105, is that right?
I can't remember the
I don't remember the number. But there is an act that directly addresses retail to retail.
Does it say you can? What's it say about it?
I would have to
So
read
you
it. I
don't
would
think
hate to
you
quote
got-
it to
we
you
can hear
without
up here.
having it in front of me.
I was wanting to know what it said about it, in a nutshell.
I can get a copy of that and have someone bring it to me unless you.
Sharon, what are you getting a copy of, so everybody will understand?
I'll get it. I'll have one of my people bring it over.
What?
Huh?
What are you getting a
Oh,
copy?
the legislative act that has to do with retail to retail. I'm sorry.
So we couldn't hear up here.
To paraphrase, there was a legislative act that was created approximately, a couple of years ago?
0506.
0506. Prior to that day, retail-to-retail sales were specifically not allowed in the Cherokee Nation. That act allowed it, and also we collected a surcharge on the retail sales of $1.50.
At all, Ms. Fitchinghott?
So the act allowed it, the one
The
that
act,
passed.
our act, 0506, did allow it with a $1.50 surcharge.
I'm confused here. But the state can come in and tell us that we can't do it after we pass an act that said we could.
Normally, if I can answer that,
Yeah.
and Mr. Henry, if you want to stay up here, I'd welcome your input. The state obviously can't tell us what our law should be. We also had an act that ratified this compact, that agreed to the terms of this compact. Then we had a dispute as to what those terms meant. This panel that we agreed to has now told us what those terms mean. So we are bound by that. And that's not the state telling us, that's, we agreed to be bound by the compact itself, this body and the principal chief in contracting with the state. We had a dispute as to what that meant. Now we've been told it went against us. So it's our own law that in effect tells us we have to enforce it.
Any other questions? Yes, Dr. Cobb and Mr. Thornton.
I have a non-tobacco question for you.
Excellent.
I have received several phone calls, more than just a few, and essentially they all go the same way. There's a family dispute. A lot of times it's a divorce, and the latest one was in Delaware County, and lady goes before the judge. There's a divorce. One of the things she's asking for is health insurance coverage to be paid by the ex-husband. Okay. And the conversation essentially goes, well, aren't you Indian? And the answer is yes. And well, you don't need health care coverage. You can go to one of the clinics or IHS, which A, I find appalling, and B, it's my understanding that there has been some discussion on that and the possibility of some letters being written. Do you know anything about that?
I don't, but I'll find out, and it may be that our Child Support Enforcement Division has made some sort of recommendation or some sort of policy about that. I know, I could speak for Melissa Gower, I know that she'd find that appalling too, because even, you know, if you do to go to one of our clinics, we want you to have that insurance because we want to be able to bill.
The insinuation is that it's free health care, and that's
right.
just not the case.
Right.
And
no, it's not the case.
And I would welcome some thoughts along the lines of maybe some communication with the Oklahoma Bar Association and DHS and some other entities, if at all possible.
Certainly, and I'll research that and see.
Thank you.
Mr. Thornton?
Diane? Have you reviewed the 1866, 1868 treaties which involve the paying of state taxes?
The tobacco
Any state
provisions,
taxes?
yes.
Do you have an opinion? Have you ever given an opinion on that?
We have.
Treaties?
I need to give you a copy of our brief because we argued that, and the state addressed it as to whether or not we were liable to the state for any taxes on manufactured products that came out of Indian country. We did make that argument and we lost. Now it would be clearer if we, grew the tobacco on our land, harvested it on our land, manufactured it on our land, made the cigarettes on our land. That's not the case. But let me get you our brief so that you can see the arguments we made.
Okay, thank you.
Any other questions for Ms. Hammond?
May I leave these?
Go ahead.
I was just going to say, may I leave these hard copies somewhere, maybe outside or something, or?
Yeah, we can leave. Oh, okay. Are there enough for everyone?
There's 20.
Okay, and they're
copies of the order itself.
Oh, okay. Yes.
We all have
She'll give them to
copies.
Gail. She'll make them available.
Okay.
Thank you.
Thank you.
Jody, did you have another question for her?
Not of her.
You had your hand up.
No. I was going to ask you, since all the tobacco people are here, if one of them could say something. Since all the tobacco people are here again, if one of them can address us.
Mr. Levinson, did you want to publicly address?
Yes, I would. Thank you very much.
We'll give you 3 minutes because I know how you are.
Thank you, Madam Chairman.
Welcome. Thank you for coming.
And I just heard about, I heard about it last week, and again, I was notified today of the actions that Tribe took. And first, I want to thank everybody in this council for standing behind us, and also want to thank Chief Smith, too. I know he's in a difficult position running the tribe and trying to maintain relations between the tribe and the state. But if I can say this, first of all, as far as this arbitration ruling I just received, I haven't read it, but, when you have something, and I guess I've practiced law over 30 years now, and when any arbitration panel can rule that the waiving sales tax didn't violate the compact, really puts it at another level, because if you can read and write, that's pretty hard to comprehend. And I was at this council before the compact was signed, and the chief was here, and Julian's fight, I'll never forget, and I have to tell you this about Julian if you're listening, and I said, Mr. Fight, we need to put in that compact about sales tax. He said, oh, no, we don't. They would never do that. I said, Mr. Fight, we need to do it. Well, after some discussion, I know Mr. Lane and the rest of the group were here, we put that in there. Well, after they waived the sales tax, I went back in his office here, and he said, boy, you were right. And he said, I'm going to get even with it. But I do remember that. But here's where I think we are. I mean, we're in a situation where this Cherokee Nation didn't create this problem. They didn't create it. You can't have 7 tax rates in the same state and the same geographic area. We've got the Creeks, we've got the Osage, we've got 4 or 5 other tribes that compete. The Creeks don't have a compact. If this would be enforced in Tulsa, we'd be $1 some more than the Creeks having this compact. You know, the thing is, I can talk, you know, I feel kind of like I saw a war movie and I saw the German general come after the war was over, and he meets with the Americans. He said, I want a negotiated peace. That's, you know, that's kind of the way that I feel today. But, you know, what can we do from here? I mean, obviously I haven't read it, but, you know, the arbitration ruling is what it is, and when you practice law, and the chief knows this, when you start expecting things, you can't do it. So I've got to live with what's on this piece of paper. As far as the favored nation clause, let me raise that. Some of the new compacts put future in there, and I understand the arbitration ruling that it has to be something done in the future. I will tell the council this, and I think this is very important. Recently, the state raised the rates, I believe it's on the Otoe, Missouri, and the cause, and they had let that compact, they didn't terminate that compact in time. At least that's the tribe's argument. The state sent a letter out, raised them to the compact rates, probably $8.58, whatever that amount is, irrelevant when I'm telling this council. $7.75? $7.75, which would be the non-compact rate. The tribe took action and sued them and stated that the rate was 25%, that they had not terminated contract time, went into the extended term. The state immediately rolled the rate back to 25%. And if those 2 compacts were extended, of course, I have to temper my words when I see that they don't recognize sales tax as a violation of a compact. The only thing that we have going in our favor is that we need to invoke the favored nations clause, that these compacts are in their extended term, which they are. They terminated, so they're still at 25%, and at least we need to use that as a buffer. And one other thing I have to tell you, and I've told this to Chief Smith, and the Creek Nation asked me, some of their council people, when they were negotiating their compact. And I'm in a funny position because I'm also in the tobacco business, and I've done work for a lot of the people in this room, and I don't think I've ever sent anybody a bill in here for work. I don't think I have. And it's a pleasure to serve the nation. Rule 12, when that came, and as I told this, when they segregated a group of people and told them what they could sell and what they don't sell, that's the first time in my life I really saw what discrimination was. And it raised my awareness to a different level. But what I want to tell people is, at least the group that I'm helping, we understood the state of Oklahoma wanted more tax. And they're entitled to it. I mean, I don't like it, but they're entitled to it. They've got a thing. And I talked to the chief about it. In fact, I handed the chief a paper. What I didn't understand is if we pay the state the tax they want, which is like $4, give or take, the chief knows it, $4.20, $4.30, $4.60. I thought it's the Cherokee Nation itself that determines what they charge us. I do not understand how the state can mandate what the Cherokee Nation charge the Cherokee retailers for their tax. What this boils down to, it's not a tax issue, it's a competitive issue in order for certain retailers in the Tulsa area not to allow us to stay in business. That's what it's all about. In fact, the proposal I made to the Creeks, and I gave Chief Smith a copy of it, was that the state gets their tax. And if it can be, and the tribe can set a tax. At that time, what the state wanted, which was like $2.50 or 60 cents. That's what was proposed. But I put a paragraph in there that if we can show that the tribal retailers are being at a price disadvantage based on non-tribal retailers, that you as a council and the chief could lower the tribal tax until we were on a level playing field. So the state can't complain, they're getting their tax money. Well, see, they don't want to do that. So that's what made me think it's not a tax issue. But again, we just need your all support. You've given it in the past, and I'm hoping in the future, because at 8:58, I've got everybody here in the Tulsa area. We just can't survive, especially the Osage right now. Again, they're transferring cigarettes. The Creeks are using Creek Wholesale, and I'm proud to say this, at least the ones that I do, to me, those cigarettes are illegal. They're not with any Oklahoma state stamp. I think that's contraband, and the shops that I'm involved with, people I represent, will not handle and have not handled those cigarettes without proper tax stamps. But I've lived and breathed this stuff for years, and I would welcome any questions. I know I could talk for an hour, but I really do feel this, and it's not a matter of charging these people, because I haven't sent them a bill. So,
Dr. Cobb has a question.
yes, sir, Doc.
Not being an attorney, I want a clarification. When Ms. Hammond said that the arbitration board refused to look outside the four corners of the arbitration document.
You mean of the compact?
Of the compact.
Yes, sir.
What I'm hearing you say is intriguing, but is that not outside the four corners of that compact? I mean, how do you, it's not?
No, it's in the compact. In fact, it's ironic, and I appreciate you asking that question, because when we went to district court, even a district court judge you figure would be on the other side of the fence, he saw that we actually complied with the compact, because the way they wrote the compact, there's two things. It says taxes collected at the first incidence when it's sold for resale in Indian country. That's been defined. There's a Seneca case and three more. Chief's an expert out. I'll tell you, Indian country is defined as all our shops. So basically, that was for resale at that point. But there is a question, was that the intent to transfer from one to another? And, to be honest, you can see how somebody see that the other side. But on the sales tax issue, no. Now, on the favored nations clause, the embodied in the compact, okay, let's talk about that. If you look, it doesn't say future compacts. It says just any. Now, the other compacts, I didn't bring them all, but I've got some. They use the word future. See, they didn't differentiate. But in this case, to take out any ambiguity, whenever those compacts were extended and it went into a subsequent term, by law, that's going to be a future compact. You see what I'm saying?
I see what you're saying. My question originated, too, from the statement that you made that what this is a competitive issue.
Yes, sir.
Doesn't that fall, if you were an arbitrator or if you were, you're an attorney, does that possibly fall outside the bounds of the compact? Because to argue this is a competitive disadvantage issue, I guess my question is anybody going to listen to that?
Well, I don't think that, and that's a very good point. It had nothing to do with the arbitration. Competitiveness should have nothing to do with it. It should be this document, what it says, and what was done.
Okay, that answers my question. Thank you.
Any other questions for Mr. Levinson? Well, you did good. I even let you have 5 minutes.
Thank you. I appreciate that, Madam Chair.
Thanks for coming.
But I would just ask everybody to consider, the favored nations clause, and I've got, faith in our chief here that will try to treat us right, and I do for all the people we talk to. We appreciate the effort, Chief.
Next report is Election Commission. No one here from there. I think they said they give us a report. No one here, so we'll move on down to Tax Commission. Ms. Swepston? Oh, there you are.
I didn't go back. I just stayed up here. I think you have my written report, and I'll try to address any questions that you might have about that report at this time.
Any questions for Ms. Swepston? Ms. Kishinghop?
Yeah, last month I'd asked her to bring me a breakdown of the drop in tobacco sales at our tribal locations when they went up to the new rate.
Yes.
And you never sent it to me.
We worked on part of it. We're trying to get some reports because you wanted several years' worth, and our database, I think you requested like 2 or 3, but we only had it in our database for 1 year broken down that way, and we can get you that, but she was trying to get the whole amount that was requested. But we can send you what we have if you'd like.
Okay, you sent me 1 or 2 sheets last month when I requested it that day. I've lost them, and I was wanting all the council to look at. Can you not give us them 2 sheets in the meantime?
Yes. I can get those back to you.
Okay. Anything else? Ms. Jordan?
Sharon, did you consider our flexible hours idea to maybe be open a couple nights a week? to
We
let
have,
the working people come in?
I actually spoke with my commission about that during the commission meeting. They didn't have an issue with it. I have met with my managers, and right now they're trying to see if we actually have staff that would be willing to do that. So we are looking to see if we can actually do that.
So without increasing the number of hours for the staff, maybe some could come in late and stay a little later?
That's what we were trying to see, because we have a lot in our staff, the majority of them are younger parents, and so we were trying to see if we could actually work that out, because they have children, and I know sometimes that poses problems. So the managers are trying to work with the staff to see if that's even feasible.
Okay, and then I've noticed, not a lot of times, but several times we have gotten notice on our Blackberries that your office, for one reason or another, had to be closed.
Yes.
How are we communicating that information to the public?
If it's like the training day that we had, that's gone out into the Cherokee Advocate. We put it out through the email. We also send it out through our communications department to let them get it out into the newspapers in those local areas that were going to be closed on those days like that.
Yeah, are we getting it out to the local newspapers, though?
My understanding was we were.
So we haven't had any complaints?
Haven't had any complaints. The one that we had to close this week, the cable had to be replaced. That was something that couldn't be helped. It was either going to be down or try to be replaced, and they're still working on that because they didn't get it completed.
Just so we're getting that information out to
Yes,
people,
we're trying our
so
very
they're not
best.
taking off to come to the tag agency and us be closed.
On the 1 day per quarter, we try to get those out on several different times so that the notice is out there, plus it is posted in every office. So we post it on the windows also.
All right. And do you have a timetable maybe on the flexible hours thought?
I don't yet. We're working on that. I'll try to get you something back on that.
Thank you.
Any other questions for Ms. Whipson? Thank you for the report. Self-governance, Ms. Hanby. Good afternoon.
I believe you have my written report, and I'll just give you a couple of updates since the report was submitted. First of all, we have all of our MOUs and our funding agreement have all gone to DOI for processing, so we're just awaiting signature from the DOI officials, and that'll be done. One other item that I wanted to update you on is we completed the OST, the Office of the Special Trustee, came in and did a review last week. That went really well. They had some very complimentary comments regarding our Real Estate Services Department, and they said their files and their system is, if not the best, one of the best that they've ever seen. They also made comment about as large of a group as we are, that Realty and Natural Resources and all of our departments work very well together and communicate very well together, and I thought that was very complimentary of the staff, that they work well together. One other item to update is the Title IV Amendment meetings that we've been attending. We had scheduled to meet with the Department of Interior for a last meeting with congressional staff on April the 8th. That has now been canceled by the Department of Interior, so we're looking to reschedule that or something else. But that's all the updates that I have, unless there are any questions.
Are there any questions for Ms. Hanby? Mr. Bezer?
Yeah, Vicki, on the contract support out of DOI, is that a large number that we're looking at on contract support costs?
As far as
The dollar amount that we're trying to negotiate with and we're trying to get from us?
well, actually, what's happened is they implemented a contract support cost policy. It's different. In other words, it's a different methodology of payment than what we've had in the future or in the past. In the future, they've allowed us to be paid direct contract support as well as indirect contract support. However, we've only got about 2% of the 15% that we were to get, which is 15% of direct salaries. So basically, we just don't have enough, Congress is not appropriating enough money for it to really have a huge impact on Indian country. And that's both with IHS and DOI, but.
And even on the road compactor contract, we still don't get any contracts for $4
No.
on those either, then I take it.
No.
Thanks.
Didn't we get all of our back pay on contract support in that case we won? Did we get all of that?
Well, now that's with IHS. We did win the case that went to the Supreme Court. However, even with going all the way to the Supreme Court and obtaining a unanimous decision from the Supreme Court, we still aren't seeing a big impact from that in Indian country, and that's both with IHS and DOI.
Any other questions for Ms. Handy?
The main thing we need is to work with Congress to appropriate more money, and that would actually benefit every tribe in the nation.
All right, thank you. Mr. Hummingbird.
Good afternoon.
Good afternoon.
I believe I too have a report included in your packet this month, and would like to I think there were two items that was not able to get in there by the time I submitted the report, but there were two pieces of proposed legislation that came to my attention after submitting the report. The legislation has to do with one item was introduced by Senator Vitter out of Louisiana, and that's Senate Bill 2676. The title of that proposed bill is the Common Sense Indian Gambling Reform Act of 2008. And what Senator Vitter is trying to do here is amend the Indian Gaming Regulatory Act by allowing the NIGC to expand its authorities and scopes into the Class 3 gaming arenas, allowing them the ability to go in and assert their jurisdictional oversight over Class 3 gaming. That's not the only provision, but that is one of the main provisions that is of concern. And I'll be continuing to watch that particular piece of legislation as it goes forward. The second piece is a resolution that was introduced in the House, number 5608, introduced by Congressman Ray Hall. And that draft bill is cited as the Consultation and Coordination with Indian Tribal Governments Act. I just received that one very shortly, a short time ago. I have not had the ability to really digest it, but the overall intent is for a consultation policy to be developed that will be applicable to all federal agencies that will get them into compliance with the presidential executive order regarding consultations with tribes. So I believe those are the only two pieces of information that I did not get to include in my report to you, but I'll be glad to answer any questions you may have.
Any questions? Yes, Mr. Baker?
If I think the Senate bill passed where they would regulate Class 3 as well, how would that affect us?
It really puts us in the position of having to work with not only the NIGC but with the state, because what will happen, the way I see it happening anyway, is the NIGC would take a look at the compact that we have with the state, analyze it section by section, and be on the lookout for particular areas that they may deem or they may feel is not up to their level of expectations as far as performance. They'll look for provisions that they feel they have a much more stringent set of requirements and will attempt to impose those sets of requirements on the tribes versus what is in the compact. So if, let's say, for example, we have a set of internal controls that we use at our gaming facilities. If the NIGC deems that those level of internal controls is not sufficient in their estimation, they would then seek out to insert their own level of internal controls over and supersede what's contained in the compact. So in short, if the NIGC does not feel that we are being strong enough in our regulation, they would look to assert their influence in getting that regulation brought up to a level that they feel comfortable with.
But would that necessarily be a bad thing for this government?
Depending on what the actual effect is, that's one thing that the NIGC is not necessarily known for doing, is really analyzing to see what the cost benefit of a regulation is. So there could be more cost to a tribe, this tribe or other tribes, with whatever regulation they would want to put in place, as compared to what has been being used by tribes and being used by the regulatory personnel to meet the intent of IGRA and in some cases meet the intent of the compacts. So, there can be such a thing as too much regulation, is what I'm trying to say. NIGC is not necessarily been known to look at regulatory matters from a more practical standpoint as to, is the cost going to outweigh the benefit?
Okay, thank you.
Mr. Sugg?
Yes, I don't know much about gaming, but is there a commission that regulates gaming throughout the United States for the state of Louisiana or the state of Nevada?
No.
Okay, so it's just Indians that have to abide by some commission's oversight across the United States?
Correct.
Okay.
Correct. In short, when IGRA was enacted back in '88, what led to that were many in-state battles, mostly in California, some in Florida, that led to IGRA's passage. And IGRA simply states that the NIGC will regulate the gaming conducted by tribes across the country. Gaming for Class 2. Now, Class 3 will be done concurrently with the state and the tribes. NIGC has no authority. But they felt that the states had the better ability to regulate Class 3 gaming, since a lot of them did already offer Class 3 in the form of either actual casinos or lotteries and such. But there have been no central organizations, and I don't think you'll ever see one for regulation of state gaming.
Convenient.
Very.
Any other questions for Ms. Hummingbird? Thank you for the report.
Thank you.
Mr. Henry, where are we on codification? Where'd he go? Okay. Is Diane still here to report on GEG? Is anyone here to report on GEG? Yes. Did you have anything to report on GEG investigation report?
All I can tell you is that there's been significant action in the last month, and the federal investigation is still ongoing. That's about it.
Thank you. Thank you. Mr. Henry, codification.
That's codification. We do have another codification meeting tomorrow at 1:30. Anyone's welcome to attend. Mr. Morton and Ms. Johnson, who are present somewhere around here, will be taking part. We can plan on completing the assignment of legislative act to titles, and then tomorrow we will also divide up the titles amongst ourselves and start doing the line-by-line check. So things are progressing smoothly.
Any questions for Mr. Hembry? Okay, next order of business is old business, and the first item is presentation of recommendations of officials' compensation. Mr. Garvin?
Because of a couple of complications, I'm going to make a motion to table this to the
Second.
April rules meeting.
Table to April. Did I have a second? Any discussion? No, we're done. Table. All in favor, signify by saying aye. Aye. All opposed, same sign. Okay, it is tabled to April. This next is an act relating to division of question. Mr. Baker.
I would also ask that that be tabled until next month.
Second.
Moved in second. All in favor, signify by saying aye. Aye. All opposed, same sign. Under new business, there's a resolution confirming nomination of Pam Bickford as on the Economic Development Trust Authority Board. Ms. Knight?
Good afternoon.
Move to approve.
We still want her to introduce, but I want to.
I'm happy to present Pamela Bickford as a nominee to the Economic Development Trust Authority Board. And just for clarification, that is our loan board, our commercial loan board. And she is a self-started entrepreneur. She started her own business and has grown it and continues to successfully run it. And I have to say that she is probably one of the most passionate people about Cherokee entrepreneurial development that I've talked with. And so I'm just happy to present Pamela Bickford to you.
Hi. Kara, did you have a...
And I just wanted to say that I heard the comments from our council concerning folks that work in the community, that are Cherokee, that do day-to-day small business stuff, and that really is, for me, Pamela Bickford, even when I look out across the 14 counties. She has built a business from scratch as a Cherokee woman, and she now does a significant amount of business. She's been through the loan process. She also does HUD zone development, and she researches how you do all the 8A and everything else. And so I think that she will add a lot of value as a Cherokee woman to this board. And I'm honored that she accepted the nomination.
Thank you. Would you like to say a few words?
Certainly, Madam Speaker. Thank you all for having me and entertaining this idea to bring an entrepreneur to your finance board. I think it's a real visionary thought on your part. I think in order to expand Cherokee-owned businesses, it takes vision. It certainly takes passion, and it does take money. The opportunity, I think, for entrepreneurs to come before a committee and have a person that is like-minded to understand their challenges is very important. It would have been important to me to have that opportunity. I know many of you all are entrepreneurs. And if you think back to just the fear factor of being denied and turned down and the challenges, and you're washing toilets at 10 o'clock at night because that's part of the passion of starting your own company. And of course, on the other end of the stick, we have institutional jobs, which Cherokee Nation is doing a great job at doing, but the private sector is what floats a country, and that's certainly where the major job creation has historically always been, and I believe it can be significant for the Cherokee Nation, given the proper support, proper networking. And we visited a little bit before the meeting about consortiums, bringing together those tarot companies where we can go after these large bundled contracts that are perhaps out of the reach of a small company like mine. But if I were to team with 2 or 3 other Cherokee businesses, we could go win that, bring that business and those dollars back into the Cherokee Nation. So I'm excited to be looked at for this opportunity and to serve the nation. Is there any questions?
Any questions for Ms. Bickford? Entertain a motion.
Moved by Buell and seconded by me, or moved by me and seconded by Buell.
Any discussion on the nomination? All in favor, signify by saying aye.
Aye.
All opposed, same sign. Welcome and thank you for your time and helping us. Next is confirming the nomination of Frida Van for the Cherokee Nation Community Association Corporation Board of Directors.
Thank you, Madam
Ms.
Speaker.
Coates? Oh, you're going to do that for her?
Well, I certainly would defer to Ms. Coates first if she'd like to speak to these nominees. These were recommendations from the at-large counselors, and the chief has nominated them for, there's 3 of them, as you can see, for the Community Association Corporation Board of Directors. So I would defer.
Ms. Coates, can you hear all right?
I can hear you, yes. Do you hear me?
Can you want to say a few words?
We are very excited about the nomination of Frida. She has worked with the at-large community, the picnics, for a couple of years, so she's gaining quite the awareness of who she
Lost her. I move for Frida Van's approval.
Any discussion on Frida? I'm assuming, Frida, do you want to stand and say a few things before we vote?
Well, I just want to say I have worked with about most all of y'all out in the communities, because that is what I do, working out with, in the communities, and And occasionally I do help with the hog fries. So, but I have done the picnics out in California last year, and it was a great success, and the people are very excited again this year. Mostly those people out of the area of the 14 counties, they really are hungry for the connection from Cherokee Nation, and they really like having that contact with us. And so I'm be happy to serve on this council or board and do the best that I can.
Any questions for Ms. Van? All in favor, signify by saying aye. Aye. All opposed, same sign. Thank you. Thank you. Item 3 is confirms the nomination of Patsy Edgar to the same board of directors.
Second.
Moved and second. Any discussion? All in favor, signify.
Aye.
All opposed, same sign. Okay. Next is confirms nomination of Jim Ketcher to the
Move to
same.
approve.
Second. Moved and second. Any discussion? All in favor, signify by saying aye.
Aye.
Opposed, same sign. Number 5 is an act amending Title 63, the Environmental Quality Code. Mr. Elkins.
Yes, Madam Chair. This particular act amends that act so that we can increase the members of the Environmental Protection Commission from 3 to 5.
Move to approve.
Second.
Moved in second. Any discussion? Any discussion? All in favor, signify by saying aye. Aye. All opposed, same sign. Motion carries. Ms. Calmwat?
Madam Speaker, on behalf of my fellow council people in District 8, we would like to move to amend the agenda to add an item that's been passed out concerning some real estate that needs to be, City of Collinsville has requested to annex.
Second that. Yes.
Motion is to amend the agenda to include this real estate, what is it exactly?
Madam Speaker, what this is, if you allow me.
Sure, please.
It's a piece of property that Tulsa County deeded over to the Cherokee Nation for a community building, and it's an existing cemetery. And so what we'd like to do is annex this into the City of Collinsville for inspections and stuff, so the organization and the group doesn't have to go to Tulsa County downtown to get inspections on the community building. Collinsville can do them all, and then plus the City of Collinsville work in conjunction with this organization to make sure they get water and sewer and different things like that.
So my motion is to amend the agenda to consider that.
Todd, do we need any legislation to do this?
I'm going to assume that we will need a resolution to allow the annexation of the property that is now fee simple in the Cherokee Nation. Is that correct?
That's correct.
And we would probably what would be appropriate for the City of Collinsville is for us to pass a resolution supporting or allowing the annexation to be submitted to their next City Council board so they could act upon the actual annexation.
And there is time it's sensitive on this because they are pouring concrete and stuff, and they need to get these inspections from the City of Collinsville. They have a temporary building permit, but we need to move it quickly so they can connect with the City of Collinsville.
What I would recommend, Madam Speaker, is to amend the agenda and then discuss and vote on this issue and to place it on the full council meeting. In between that time, I will get with Ms. Donaldson and get the appropriate resolution language that would be needed.
We have a motion and a second to amend the agenda. Any further discussion? Mr. Crittenden?
Could I tackle a friendly on to that, Kara, so that we might discuss and take possible action on the most favored nation clause of the tobacco compact?
I'll accept.
I'll accept it.
All in favor of amend the agenda to include his friendly amendment, signify by saying aye. Aye. All opposed, same sign. Okay, we will include as item number 7. Yes, Mr. Hoskin?
This is more of a point of order, and I
certainly don't oppose including these, but procedurally, how does the waiver of the time limit fit into this? Is it just implicit in that we've amended the agenda so there's no issue? I'm trying to understand how the time limit
Yes,
works.
generally, it's a 10-day notice, and we don't like to do this at the last minute, but Mr. Anglin said it was very time sensitive. Mr. Anglin, is there some reason why it got to us so late?
Yes, we just found out yesterday that the city of Collinsville couldn't do the inspections that we need to have, that we would have to go through Tulsa County, and that's a long process. And the city of Collinsville can streamline it for us, so they can keep moving with their building, their community building. Other than that, we would shut them down for 30, 60 days, 90 days possible.
Okay.
Thank you very much.
Okay, next item is item 6, possible action on the redistricting map that came from the Rules Subcommittee. Ms. Fishing-Hawk, did you have a comment?
Yes, I have been talking to Mr. Justice, and he thinks he has come up with a more accurate deal. There was a lot of discussion between everybody, I think Harley's one of them that voted no, and I voted yes. And I think you all had questions about using the most accurate numbers available.
Yes.
Since we found some numbers out, and none of us is quite ready to go, or a majority isn't, I want to make a motion to kick this back down to subcommittee for another month.
I second it.
Moved and second. Any discussion on putting this back to the Rules Subcommittee? Any discussion? All in favor? Oh, Ms. Calwatt, sorry.
I'm not going to support this because I felt like Mr. Garvin and I have been very patient in trying to move towards some kind of resolution. I understand why people are unable to support it, but I hope you understand what actions I'll have to take next in order to keep the representation for my district fair, because I've been through this. We went through this last time, and when it was delayed and delayed and delayed, that just meant that then when the time it came for a lawsuit, the courts felt like they couldn't answer it. So I appreciate your time, Madam Speaker.
Mr. Garvin and then Mr. Hoskins.
Yeah, I think this is number 99 as far as delays goes, and I definitely think that, and that brings up the point that was passed with the council in 1999, so it's taken us a while to get in gear. I guess we're illegal at this point, and definitely we need to do something, but one or two can't do it. Thank you.
Mr. Hoskins?
Well, Madam Speaker, one person's delay is another person's careful deliberation, and I think that's what Councilor Fishing-Hawk is asking. She's brought to light some different numbers on the population, which we need to take time to consider. I had asked at our last meeting for a report on how these numbers were derived, which I think is really prerequisite for us taking any action. I don't think we have the time here to consider this issue given the information that Councilor Fishing-Hawk has obtained and giving the information that I have not yet received. So I think that's ample reason to simply move it back to subcommittee. I think it's just part of our deliberative process. It may not be as quick as some folks would like, but I think it's proper. So I support it.
Jody, did you have a
I was
question?
going to ask Todd something. Todd, what do you think is a reasonable timeline to have this? If it takes a couple more months.
Well, it's like beauty's in the eye of the beholder, what a reasonable amount of time it is. You are approximately 3 years to your next election. Are we to the point of no return? I don't think so yet. However, I would not be dilatory. This is going to be a process, and we can't. For instance, I was going to recommend, depending on the vote, that we set the next subcommittee for our regular council meeting date. Keep this on a fast track, get that information in here, and get it done. And if we have to defend the actions of the council in any other forum, that we're working as hard as we can, and we're trying to deliberate and get all the information. Don't put this on a slow track. Put it on the fast track. If you do table it, or send it back to the subcommittee, or keep it on the regular agenda, or let's set that subcommittee real soon.
we have a standing meeting for that subcommittee on the day of tribal council.
Tribal council meeting, okay.
Mr. Enlow?
Yes, I just,
The tall boy?
I just wanted to briefly describe what's going on. I sent a report earlier, about 2 weeks ago, of how we derive the numbers. Did you guys not get that?
No.
Okay.
Well, I didn't.
It was the day that we were conversing back and forth. Later on that afternoon, I sent it to you. I'll send it again. But it was a PowerPoint that actually has some of the maps that describes how we came up, how we created the data, how we've analyzed it, we've looked at it, and it gives a history and a detail of when we got started on the process. And I'll find that and I'll resend it back to you so you can get it distributed out to them. And I'll do that today. So it provides a history of how we're doing that. David Justice has diligently gone out and racked his brain and thought of every possible way to make sure that we have good, viable, and intact data, something that you all feel comfortable with. And we've described in the past that we've tried to geocode the residents and the citizens and where they live. And that worked well in 7 of the 14 counties and worked poorly in the other 7. So David has contacted the State Election Commission and talked to them about how they derive their data. And they use geocoding by a mathematical analysis. So the census publishes street data. And the beginning of the street is the 1,000 block and the end of the street is the 8,000 block. And mathematically they geocode across that street and they break it up into equal segments and say, roughly this should be right around the 7,000 block. And it's fairly accurate. And that is the way the state produces its election data. So David tried that about a week and a half ago with our data, and we had about less than a 50% success ratio, which is about where we were with geocoding. But David has been in discussion with the state. They have graciously extended an offer for him to come up and look at their system, see what we're doing differently, if there is anything differently that we can do to try and pinpoint those citizens along the boundaries to using geocoding so we can get more accurate data than looking at zip code information. So that's what we're looking at doing. So we're looking at as many possible ways as we can to make sure that the council is satisfied with the data. And that's what we're looking at doing, is going to a geocoding format and trying to get as accurate as we possibly can. But I will resend the information. It's a PowerPoint as well as a message in the body of an email message that describes roughly how we got to where we are today.
Ms. Jordan, did you have a question?
No, I just call for the question now.
Question's been called. All in favor of sending this back to the Rules Subcommittee signify by saying aye.
Aye.
All opposed, same sign.
No.
Roll call. Just yes means you agree to send it back.
Tina Glory Jordan,
Yes.
Curtis Snell,
Yes.
Krista,
Yes.
David Thornton,
Yes.
Kara Cowan Watts,
No.
Bill Anglin,
Yes.
Bill John Baker,
Yes.
Jack Baker,
Yes.
Harley Buzzard,
Yes.
Julia Coates,
Yes.
Bradley Cobb,
Yes.
Joe Crittenden,
Yes.
Jody Fishinghawk,
Yes.
Meredith Rayleigh,
Yes.
Janelle Fulbright,
Yes.
Don Garvin,
No.
Chuck Hoskin Jr.
Yes.
We have 16 yay and 2 nay.
16 to 2. We'll go back and it will be on the...
I'm sorry,
15 to 2. And it will be on the agenda for the next subcommittee. Okay, item 7 is the real estate services request for annexation. We've had some discussion on it. Mr. Anglin, did you want to discuss it further?
No, I think I covered it all a while ago. If anybody has any questions.
Move for approval.
Second.
Ms. Calmwatt?
That's all I can do.
Moved in second. Any further discussion?
Call for the question.
All in favor signify by saying aye.
Aye.
All opposed, same sign. Okay. And we will have this on the the tribal council agenda, correct?
That is correct.
Now, the second part of that is the most favored nations clause, Mr. Crittenden.
Well, I was told a little bit ago outside that without that option, or without us proceeding with that clause or with that position, that a lot of the folks may be out of business very shortly. So with that in mind, I would yield to Lee or to Joe or just Diane or to somebody.
Somebody?
Yeah.
Ms.
Okay.
Hammonds?
Certainly, we will, and that is one of the options that we're exploring, is the favored nations clause and the renewals and whether or not we can invoke that. If the council wishes to express its opinion or desire as to exploring that option, I have no objection to that at all. But certainly we will.
Mr. Hoskin?
I'd like to yield to Mr. Lane to say a few words about the MFN clause.
Mr. Lane?
Yes, I'd like to thank the council for at least acknowledging me and let me plead my case. This is an emergency because as of tomorrow, we're not going to be able to get any cigarettes. And let me give you an example. We're ordering Philip Morris because Philip Morris products, Marlboros and so forth, they've kind of said we got to buy at the $8.60 tax. They've cut all of our wholesalers off. That's 40% of our business. I'm buying Marlboros right now, today, for $33.40. I'm selling them for $34. That's 50 cents under Quick Trip. I make 60 cents a carton on 40% of my business. I can't even pay the rent at the shops. So if the council doesn't give us some relief from what's about to happen, I'm going to have to give you my keys. I cannot continue to operate. I'll be broke, and it's just like putting good money after bad. And I'm not going to do that without any help. And that's what it basically comes down to. The compact that we signed lets me make 60 cents a carton. That's not fair. That's wrong. We asked for the sales tax situation to be addressed in the compact. We were assured it had been. And now we lose it in arbitration because it wasn't written properly. So, you know, if we could have the sales tax back, we might be able to make a living. But we can't right now. We just might as well shut our doors. And that's all shops. So I'm asking you, please, as an emergency, invoke the favored nation status concerning the MODOCs or the CAWs or the OTOs. They're still at $2.58. And, you know, without that, you're going to lose 50 of your shops. Never to get them back. And I don't want that. That's 500 employees that's going to be out of work. That's I don't know how many families that count on our money to survive on. At least 50. Don't put them out on the street because they count on our money. And if you could, please grant us some more time by invoking the favored nation.
Mr. Hoskin, did you?
I had a question
Other
of
comment?
Ms. Hammonds. We heard what Mr. Levinson had to say earlier. It sounds like we have a factual basis to invoke the most favored nations clause, but are you satisfied that we have that factual basis?
No, I'm not. What I understand is the Modoc tribe, I'm looking at information provided by our commission. That's fine. The Modoc tribe compact's been in effect since 1996. The Comanche was automatically renewed for 5 years in 2003. Both of those are still prior to 2004. Then the CAW and the Otoe, Missouri are in litigation over the notice date and the authority of the governor's office regarding the renewals. I mean, certainly, we can invoke in favored nations if we have a compact to invoke it over. I'm not convinced that we do, and what I have in front of me seems to indicate that the only two we possibly could were these renewals of the CAWs and the Otoe, Missouris that are in litigation. So what I can assure you and assure our licensees is we will do everything that we can. But there is a factual dispute as to whether there's anything to invoke.
Well, with respect to the compacts that are in litigation, why not let the state of Oklahoma say, well, they're in litigation? Why don't we take the position that those were renewals and that triggers the most favored nation clause? I mean, is there any more factual investigation that we need to do beyond what we've done here today to say we can't take that position? Let's let the state of Oklahoma make that argument.
I need to see them. I need to see them and get more fully advised as to the facts. If there is, we will.
Mr. Hembry, excuse me, Mr. Hoskin, I think you wanted to comment on your statement.
Madam Chairman, at this point, this is great discussion. But what this is also is litigation strategy. And these are arguments that Ms. Diane Hannons may be making in court. And this is, a matter of public record. It's being streamed all over the internet. Whether her misgivings or her reservations about this litigation strategy may come back to haunt her in a court of law, I would ask that this type of discussion would cease. Now, what I understand is the request is for us to invoke the favored nation status or clause in the compact. Ms. Hammonds has stated that they will take every opportunity to do that. We, as a council, we would have the authority to pass a resolution exercising our support or our willingness to do that, but we, as a council, cannot do that under the compact. It's a separation of powers issue. It'd be up to the executive to do that, and we can pass a resolution saying, we support the invocation of this clause, but it is a resolution.
Mr. Hoskin, you still have the floor.
Okay, and I don't think this question will harm any litigation strategy, but if you do get to the point where you're satisfied we have a factual basis to invoke the clause, procedurally, how much time are we talking? When we saw Attorney General Fite's letter, he started out with the letter. We end up ultimately in arbitration, but what steps would you take?
If we were to invoke the favored nations clause on something, we would give immediate notice to the governor's office, to the state attorney general's office, to our tax commission, and consider it invoked, and then see what happens.
Thank you.
Ms. Jordan?
This question's for Mr. Lane.
Yes.
And maybe for Sharon. Sharon, you want to come up? This arbitration order, how much is this costing you? If this order is in effect as of, I assume, right now, how much is this costing you?
Well, it cost me 4 smoke shops.
No. Can you tell us her
We're going to go from making over $3 a carton to 60 cents a carton.
Okay. How much do we make in taxes off of each carton of cigarettes?
Right now, you're making $2.
So if we lowered our taxes somewhat to
That's with
cover...
the surtax that's in there.
That's with the $1.50 surtax. With retail to retail ceases, that $1.50 surtax will be in there, so it'll be 50 cents.
So it'll just be 50 cents.
So we're only making 50 cents and you're only making 60 cents. My feeling is we can't invoke the most favored nation clause until we answer the question. We get the question answered by the court. I think that Diane Hammonds has to litigate that. I think that only leaves this body with considering whether we would try to lower the tax temporarily to offset some of the loss that these smoke shops are incurring until we get a decision by the court of whether extensions are new contracts or not new contracts, which will either kick in the most favored nation clause or not kick it in. but we only have 50 cents to work with. I myself am willing to forego that 50 cents in favor of giving it to the smoke shop until we get an order from a court that tells us whether an extension is a new contract or not a new contract, if that will help keep them open.
Well, you've got to look at what we're going to be buying cigarettes for as of tomorrow. And that, we're going to have to be paying $8.60 a carton in taxes. Half of that goes to the state and half of it's rebated back to the tribe.
But what I'm trying to say is we can, as a body, say, yes, let's invoke the most favored nation clause. But I almost agree with Diane Hammonds, we may not have a contract to invoke it from, unless we have a court that says that an extension is a new contract. If it is a new contract, which I believe it is, I believe it is a new contract. And if it is a new contract, then there's more favorable clauses in those extensions that will assist us. But not knowing that, I don't think that this body would be proper, but I'm sure we'll be glad to go along with the majority, because I'm in the minority most of the time. But I don't think really properly that we can say, okay, we're just going to ignore this arbitration deal, we're going to invoke that, and leave it out there as another question. I think the only thing that this body ought to be considering doing is, do we want to right now forego the taxes that we receive in favor of giving that money over to the smoke shops to keep their door open while we ask Diane Hammonds to get that matter litigated as quickly as possible. Now that's just my opinion. But I sure think that's all we've got to work with.
Mr. Soap?
Yes, Ms. Hammonds, have we been in contact with the State Attorney General at all since this is, the gang has been removed? What is their disposition as far as, is it congenial, or are they, you know?
Well, they've won, so, you
Yeah,
know.
have they given us any type of hint, wink, or indication of, you know, like you got till next week to get this all ducks lined up in a row before we start
They have not.
having expectations of
You know, they've been cooperative and congenial, certainly amenable to us on lifting the confidentiality order so that we could discuss it and all of that. They've expressed cooperation regarding setting any damages, hearing, that sort of thing. They haven't mentioned enforcement to me. Of course, the state of Oklahoma is, you know, much bigger than we are, so you have the Attorney General's office, you have the tax commission. It's a bureaucratic process. So they have not. I haven't heard anything one way or the other. The only thing that I have thought of, we were sitting here in our discussion that I didn't mention, there's another case pending in front of the arbitrators, two of the same three on the Osage, and the last time I spoke to the assistant AG, they have not yet received the opinion on the Osage matter.
Thank you.
Ms. Cal-Watts?
I'm curious how much this would cost us if we forego the taxes, and clarification on what tax you're talking about us foregoing.
Well, I think there's also a rebate back to us, the nation, from the state for some portion. Sharon, can you clarify that?
So that means you want us to give them $4.75 a carton?
Here's what I see, Kara. I see a industry that's providing 356 jobs, and countless families are being supported by it at this point. In the past, not while we've been on the council, but in the past, I've seen other councils support industries, millions of dollars to keep them afloat temporarily so that those jobs won't be lost. Right now, we're sending $70 million a year over to CMB to try to create businesses to bring in jobs. Why do we want to lose 356 jobs? We need to do what we can temporarily. We're going to have to suck it up, folks, temporarily. We need to do what we can to keep the doors of these shops open so those 356 families have support coming in. That's just what I say.
So, Honorable Councilwoman, I would beg you to go ahead and make a motion.
And I don't think we have a difference of opinion here, but I would
move forward. Are you going to make a motion?
Okay, my motion is that we forego the current tax that we receive from the smoke shops, and if somebody will tell me what that rebate is, that comes back, circles right back around to us from the state.
It's,
How much is it?
it's $4, but in the compact, we're looking for the language where it says we can't rebate that back to the smoke shops.
Just a moment, please. Point of order here, Mr. Timbry.
On order, what has been the topic that the agenda has been modified for is whether to invoke or not invoke the most favored nation. Yes. I would recommend you take a vote on whether to have a resolution to either invoke or not to invoke that. This matter, I would say you amend the agenda of the Executive Finance. Let's try to get some numbers together, and then we can discuss it in the Executive Finance Committee.
As long as we do it today. Okay.
Madam Chair, I make a motion that we send a resolution to full council from this Rules Committee that we support the most favored nation tactic.
Moved and seconded. Any discussion? All in favor, signify aye. Mr. Lang, what were you wanting?
Well, Mr. Levinson said that he had what plan did you have?
Well, I listened to Ms.
Just a
Hammond's.
moment, point of order here. We have a vote ongoing. All in favor of the motion signify by saying aye. Aye. All opposed, same sign. Did you get all that, Shirley? Okay. Mr. Hoskin?
I just figured it would be appropriate for me to yield briefly to Mr. Levinson. I think he did have something related to the topic. I know we've taken the vote.
On what?
Favored
On
nations.
most favored nations.
Yes.
The vote's been taken, but I'll allow you 2 minutes.
1 minute.
All right, that was really good.
1 minute. If you all will invoke the favored nations clause, it's my opinion that the state, I believe, will go along with it. And if they don't, at least I've got some ammunition to go back to court where I was before, and I'll take my chances with district court. And I appreciate it. It's kind of like telling a drowning man to do the backstroke. I got to do what I got to do. But if you can, I would really, and what Mr. Lane said, we're trying not to drown, and that's what it is. So please invoke that. That's my last chance. I'm on life support. Thank you all very much.
Okay. Next item, our announcement. We have any announcements. Next meeting is April 24th.
Move for adjournment.
All in favor, signify by saying aye.
Aye.
Opposed, same sign.